welcome everybody for attending our webinar this evening, Setting Up Your Estate Plan for Success. I'm Jim Allen. I'm the President and Chief Financial Planner at Anchor Bay Capital. And presenting with me this evening will be Blake Pinion, Anchor Bay Associate Advisor and also one of our tax specialists. So this is a presentation we've done in the past. It's kind of backed by popular demand. It's one that people have shown the most interest in and have asked for us to do it again. And it will be an update on what we presented previously, because we do have several updates in terms of estate taxes and things like that. So let's go ahead and get started. So what we'll do is we'll go through the presentation. Blake and I will both present, and we're going to leave plenty of time at the end for your questions. So if you have questions, you can just submit them into the Q&A box, and we'll go through and answer them all at the end. If you don't want to ask a question after the presentation, feel free to reach out to either myself or Blake afterwards, and we'd be happy to talk about anything you wanted to talk about. So let's start with what happens to your money at death. So essentially, you see this funnel here, and you can kind of look at your estate, what you own as this gigantic funnel, and everything you own goes into that. That's your personal property, that's your cars, your jewelry, all of those kind of things. It's your retirement plans, like your IRAs, your 401ks, your Roth IRAs. It's individual investments like stocks, like rental real estate. It's your home, all of those kind of things, and it's business interests. So everything goes into this funnel when you pass away, and that's your estate. And then from there, we have to start taking out expenses and debts and taxes. So, if you have to go through the probate process, you're going to have to pay a probate attorney to help with the process. You're going to have to pay the probate fees to the county. There may be appraiser fees that have to be paid on things. You have to pay off any outstanding debts. You'll have to pay for funeral expenses, et cetera. And then you'll have to pay for taxes, which we'll talk about in the next slide or so. So after all these costs are paid out, whatever's left can pass down to your family or whoever you designate, whether it's family, charity, whomever. And so that's your net estate. And those assets will pass based on how they're owned and titled. So they could pass via beneficiary designation, like a life insurance policy. They could pass via a revocable or irrevocable trust. They could pass through your will. They could pass through title, like if you own your home with joint title, joint tenants with the right of survivorship. And if you don't have any of these titling designations, then the state decides who gets your money. It's called intestacy, and we'll talk about that a little bit more too. So as I talked about, your assets can pass at death on a bunch of different ways. And very likely you're going to have assets that are all going to pass in different formats. So probably the biggest one for most people are via beneficiary designation. So that's any of your retirement plans, your IRAs, your 401ks, your 403bs, any of those kind of things. You have a named beneficiary, and those assets pass via that beneficiary designation. The same with life insurance policies. If you have life insurance policies or you have group life policies at work, you've named a beneficiary, and the beneficiary receives those through that designation. So those pass automatically, and that beneficiary designation controls. Next is title. A lot of us, if we haven't implemented a living trust, own our homes through joint tenants with right of survivorship. We probably have a bank account, a checking account, a savings account, or whatever. That's also joint tenants with right of survivorship. And then there's another kind of hybrid between those two. It's what's called a transfer on death account. So you may set up an investment account, at Charles Schwab or Vanguard or somewhere like that, and you don't have a beneficiary on that type of account, but you can have it set up so that it will transfer automatically at death, what's called a TOD account. It's a little more complicated than just joint tenants or a beneficiary, but it can accomplish kind of the same thing. And ultimately, that's how the assets will pass. And then finally, you have your will. And so this are things that aren't going to pass through titling or beneficiary, like your cars and your personal property, and potentially investment or bank accounts, et cetera. So your will gather all those up, and they'll pass through the probate process and go to your heirs. Your will can also set up a testamentary trust where You don't set one up while alive, and we'll talk about living trust in quite a bit of detail, but you can set up a testamentary trust through your will, and the assets through the process will go into this testamentary trust. Then very commonly, particularly in California, we use revocable living trusts. And so though whatever's in the living trust passes through the trust process outside of any of these others. You may also have irrevocable trusts. We haven't done many of those in the past few years, but they may make a comeback given on what happens with the estate tax. And then finally, as I mentioned, if you don't have any of these methods of transferring your property, then kind of the final spigot in the funnel is the intestate process, where your state decides how assets pass. Okay, so let's talk about taxes at death. And there's two types of taxes. There's income tax, which everybody's familiar with, and then there's potentially estate or inheritance tax. And so in terms of the income tax, there's a couple things that come into play. The first is what we call income in respect of decedent, or IRD. So this is a tax on retirement plans. Now, with your 401k or your IRA, you've gotten tax deductions, and it's grown tax deferred, so you haven't paid the tax. The government wants to collect their tax. That's why they force you to take money out at age 72. Well, what happens if you pass away with a retirement plan, haven't collected their tax, then your beneficiary, whoever inherits that IRA, will be forced to pay the tax. It's what's called income in respect of the decedent. And so they pay that income tax just like you would have as they take the money out of the retirement plan. We'll talk a little bit more about that a little bit later. Other assets that aren't retirement plan related, or IRD assets, get what's called a stepped up cost basis, meaning that you can essentially sell the asset at death with little or no capital gains tax. And I'll show you an example of that in a little bit. So then when it comes to your income tax, the tax is going to be reported in one of two ways. If it's money that you earned prior to passing away, say, you work half the year and then you pass away, those wages that you earned prior to passing away are part of your final income tax return. But any money that's earned after you pass away is not individually earned. It's now part of your estate's tax return, and you have to file a separate state income tax return, a 1041. So very likely when you pass away, whoever your executor or trustee is going to be will have to have both of these returns filed. So it's very common to have to do both of those. So that's the income tax. We'll talk a little bit more about stepped up basis and things like that in a little bit. And also when we start getting into the strategies that Blake's going to cover, income tax planning at death plays a pretty big role. Now, finally, you have the estate and the inheritance tax. This is something that is kind of going to make a comeback. I started this business in 1986, and at that time, the estate exemption was $600,000. So, virtually everybody had to worry about the estate tax. The exemption was slowly increased, and the last iteration was a little over 5 million, and then it's been doubled. So currently, the way the estate exemption works is each individual has an $11,700,000 exemption. If you're a married couple, we're talking almost $24 million. So that's the current exemption. So 99.9% of the population doesn't have to worry about this tax. I spent 20 years of my career heading up a advanced planning team of 22 some odd tax attorneys and CPAs, and the vast majority of the work we did was helping millionaires and multimillionaires avoid the estate tax. I haven't had to deal with that stuff for several years now, but we're going to probably have to dust it back off. So that's the estate tax. Now, that's the federal estate tax. You could also have state or inheritance taxes in your particular state. Now, in the state of California, we do not have an inheritance tax. So if you're below whatever the threshold is, 11,700,000 single, 23,400,000 married, you don't have to worry about any kind of estate or inheritance tax. Other states do have an inheritance tax. For example, we have several clients in Washington State. Their estate exemption was kind of decoupled from the federal level several years ago, and their exemption, I believe, this year is like $2,190,000. So You could have a $5 million estate in Washington, not have to worry about the federal estate tax, but you're going to have to pay Washington state inheritance tax on a couple $1,000,000. So this is one of the things we want to talk a little bit further about, because these rules potentially could change. So as I mentioned, the current exemption is 11,700,000. This was all part of the Tax Cut and Jobs Act, the Trump tax cuts, for lack of a better term. So the exemption was essentially doubled. And so people didn't have to worry about the estate tax. Now, that whole tax bill is scheduled to sunset automatically at the end of 2025. So even if there are no other tax law changes between now and then, we would revert back to the old rules, which at the time it was roughly $5 million indexed for inflation. Meaning that next year, if the old rules were instituted, we'd be looking at about a $6 million per person exemption. So why do I bring this up? Because this is one of the things that was recently proposed. So in President Biden's tax bill, we talked about this on one of our previous webinars, the American Families Plan, there was really no mention at all about changing the estate tax rules. There was talk about changing the stepped up cost basis and a few other things, but the estate tax rules weren't impacted at all. But what happened is when the House actually came out with their version of the tax law changes, what they're called the Build Back Better plan now, there were all these estate tax law changes in there. One of them was, we're going to go back to the old rules, the 5 million index for inflation as of January 1 of next year. Will it happen? It's hard to say. I mean, we really don't know what's going to happen with this bill. What they're talking about now is totally different than what they proposed a month ago. And so we don't know exactly where we're going to end up. But frankly, there's not a lot of pushback on lowering that exemption back. So it's very likely that at some point we'll see that exemption lowered back, meaning that many of you on this webinar may have to start thinking about the estate tax again. So if you're single, you'd have a $6 million exemption, which is indexed, so it increases by several $1,000s each year. If you're married, you're looking at $12,000. So discussions that I used to have pretty much daily with people about avoiding the estate tax, those are being reinstituted. We've had conversations in the past couple of weeks with several clients about what we do. And Mike will talk about some strategies that we can use in the future. But the other issue with what's been proposed is a lot of the stuff we used to do. Things like irrevocable life insurance trusts and family limited partnerships and grantor retained annuity trusts. This new proposed bill, the one that's in Congress now, will essentially eliminate all of those strategies. And so we'll be a lot more limited than we used to be in terms of the planning. So it's something, obviously, when we're doing estate plan reviews with our clients at the year end, we'll have to look at, is this going to be an issue for you or isn't it going to be an issue for you? And certainly, if you're at a level where maybe this could become a concern, maybe not today, but with growth in the future, it could be, we'd want to review what your estate tax situation is looking like. Okay, so how does the estate tax work? So the estate tax rate currently is 40%. It used to be 55%, so it was even more onerous. But what you do is you start with that funnel that we showed. So all of the stuff that gets thrown into the funnel, that's your estate. From that, you subtract some deduction. So if you're married, you can give everything to your spouse and not have to worry about the tax. You have what's called the marital deduction. You can give money and property to charity. You get a charitable deduction. So that reduces your estate. And then from there, you reduce the estate by the exemption amount. So if your taxable estate, what's left after your marital and charitable deductions, is less than the exemption, you don't have to worry about it. If it's above, then you got to pay estate tax currently at 40%. We'll see if that rate gets bumped back up to the old 50 and 55% rates. Now, this exemption that you have can be used while you're alive. It can be used at death or a combination. So you have, say, a $6 million exemption. You can use $1 million of that while you're alive and give things to your kids and grandkids and save $5 million for a death. You could save it all until death. You could use it all while alive. So it's a unified credit, meaning that you can use it while alive at death or both. So you don't get a $6 million gift exemption and a $6 million estate exemption, you get one $6 million exemption. So now let's go back to income taxes, because again, probably for the vast majority of you, even with the proposed changes, you probably don't have to worry about the estate tax, but you probably definitely have to worry about income taxes. And so I mentioned you have what's called IRD, or income in respect of decedent assets. That's your retirement plans. So the way this works is you pass away, you pass your IRA down to your kids, they pay the income tax when it's distributed. Now, there's no 10% penalty if they're under 59 and a half or anything. Death is one of the exceptions. And this is another change over the past couple of years. Is before, whoever your beneficiary was could spread that inherited IRA over their lifetime. Now the rule is that the shortest or the longest period of time that they can take that money out of that IRA is 10 years. So what we used to call the stretch IRA, where you'd stretch it out over a lifetime and spread the tax out, has now been severely compacted to no more than a 10-year period. So the way that works is sorry about that. The way that works is that, maybe one child is in a very high tax bracket and they don't necessarily want to take it all out in 1 year. They can spread it out. Another child is in a low tax bracket, they may take more out up front while they're in a low tax bracket. So you can mix and match. As long as it's empty by the end of the 10th year, you're good to go. So you could take a 10th every year. You could take half in 1 year and the rest over the remaining 9 years. You can do whatever you want. Now, when it comes to a spouse, you can actually just pass that IRA to your spouse. They can roll it over to their own IRA, and they can defer the tax until they're forced to take it out at 72. Now, if it's a Roth IRA or a Roth 401k, those are non-taxable. So you still have the same rules, but because there's no tax situation, it may make sense to take that out sooner. Again, it depends on the individual's tax situation, but it's the beneficiary that pays the income tax. Now, for the non-retirement plan assets, you get that stepped up cost basis. And I'll show you an example how that works. So the way the stepped up cost basis works, and again, it doesn't apply to retirement plans and other IRD assets, but your stock portfolio, your house, your real estate, all of those kind of things, the value from a capital gain standpoint, your cost basis gets increased to the value on the date of death. So in this example, mom bought her house for $150,000. She's owned it forever. It's now worth $750,000 when she dies and she passes it to her son. So mom's cost basis was $150,000. If she sold it, she would have had $600,000 of capital gains. She passed it to her son. Her son's basis starting point is $750,000. So let's say son hangs on to it for a year and then he sells it for $825,000. His capital gains is $75,000. I mean, if he sells it the next day for $750,000, no capital gains at all. But essentially, that stepped up cost basis just saves son capital gains tax on $600,000. So this is really important when we're doing estate planning. We want to look at all the assets and decide, which ones are the ones we want to keep because they get the stepped up cost basis, and which ones are the ones we want to spend. The ones with the most gain are the ones we typically want to keep. Again, it all depends on your individual situation, your age, your health, et cetera. But if we're talking about clients who are up there in years, in their late 80s and 90s, and death is sooner rather than later, we may hang on to an asset just to get that stepped up cost basis. Another thing to know is in California, because it's a community property state, so you have a married couple, when the first person passes away, the entire piece of property gets a stepped up cost basis. So, Joan and Bob own their house. There's, $700,000 of gain in the property. With, let's say, Bob passes away, the entire property gets stepped up to $700,000. So it's not just Bob's half; it's all of it. It's kind of unique to community property states that we have that benefit. So again, it's something we definitely want to incorporate into the estate plan. Okay, so another kind of new thing from the previous time we did this presentation is we've had a California property tax change. And I apologize to those of you who are listening from other states, but obviously here in California, this is a big deal. So most of you are probably familiar with Prop 13, where you have a very low tax base. You know, the house could be worth 10 times what you bought it for, but your tax base is much lower. But if you sold the property and bought another one, now your tax base is going to be increased to whatever you pay for the new home. So we had some exemptions where you could sell your house if you were over 55 and you could move to another house in the same county and preserve your Prop 13 tax base. Well, now we have Prop 19, which was voted in last year. It became effective April of this year. Kind of changes the rules a little bit. So what you have now is if you're over 55, then you can still carry over your Prop 13 tax base up to 3 times. So you could actually, you know, buy and sell homes 3 times and carry that Prop 13 tax base over. One of the things that Prop 19 did was to allow this kind of carryover for fire victims. Obviously, we've had, you know, terrible fires over the past few years, and so it allows for a carryover. So this is effective for 4/1/21. Where it applies in terms of an estate situation is the rules have changed, not for the better. Under the old rules, you could pass your home or other assets down to an heir and carry that basis over up to $1 million. Well, now what's happened with Prop 19 is this carryover of your tax base only applies for your personal residence, and it only applies if your child or whoever inherits that home, the child, continues to live in the home. So no longer can you pass the vacation home or rental property and carry over that tax basis. Having it in a living trust doesn't impact this because they look through to see who the beneficiaries are. But going forward, if you pass away and you transfer your home down to one of your children, they can carry over that Prop 13 tax basis, but only if one of the children lives in the home. And they've also limited it. So essentially, it's your whatever your tax base is. Say it's $250,000 plus $1 million. So the first $1,250,000 of value of the home would be exempted. And if it's $1,500,000 house, you would have an adjustment on $250,000. So pretty complicated stuff. It's brand new. It obviously comes into play when now you're trying to pass your home down to children. We have to look at that as one of the implications of that transfer. Okay, so now let's kind of switch gears and talk about the estate planning documents, what each of them do. Do you need them? Do you not need them? Pros and cons, things like that. So there are kind of, four basic documents that every person has or should have. And some of these, depending on age and wealth and everything, maybe you don't, but every adult should have at a minimum a will. They should have a financial power of attorney, and they should have a healthcare directive or living will or healthcare power of attorney, whatever you want to call it. Those are pretty much mandatory for every adult. So if you have children who are, over 19 or over 18, they're 19, 20 years old or whatever, even if they don't have a lot of wealth, they should still have a will and they should still have a financial power of attorney, because God forbid something happened to them. You as mom and dad can't do these things for them. They need to have these documents, or the court is going to appoint somebody to do these things for you. And then obviously we have revocable living trusts, which are extremely common. And then occasionally we'll have irrevocable trusts. So let's start with what the will does. So if you have minor kids, one important part of the will is is naming a guardian for your minor kids. More than likely, many of you on this webinar today are your kids are grown, but if you have minor kids, then you want to name a guardian in your will. You also appoint an executor to administer your estate. That's the person who's going to handle probate, who's going to get those income tax returns filed, file an estate tax return if needed, etc. And then the will spells out who's going to get what. So you name your kids as the beneficiaries of the will, and the will dictates Johnny's getting this and Mary's getting that, and you can specifically list the jewelry or the cars or whatever, or it can just say everybody's splitting everything equally. And so the will goes through the probate process, and we'll talk about that a little bit more in a second. Now, those beneficiary assets, your life insurance, your retirement plans, the will doesn't mean anything for those. And if we have a living trust, essentially the will becomes what we call a pour-over will, where it just says, hey, everything is going into my living trust. Everything is not that's not already in there. But as I mentioned, every adult should have a will at a minimum. Doesn't have to be fancy, doesn't have to be complicated. You probably don't need to go to an attorney to get it drafted. There's lots of different ways to accomplish that, but everybody should have a will. And in most cases, if you have a living trust, your will is, again, what's called a pour-over will, which is essentially, it just says whatever is not already in the trust goes in the trust when you pass away. Okay, so let's talk about the probate process. And it's a little bit different in each state, but the process is pretty similar. So what happens is someone passes away. The executor who's named in the will is responsible for going through probate. So you file the documents with the county. A lot of times you're going to have to use an attorney to do this. But there are services where they can help you fill out the paperwork and et cetera. Or you can maybe do it yourself. It's a lot of headache. We helped a client last year. His parents both passed away in a short period of time. Try and do it yourself through one of these services. And unfortunately, COVID hit, and he's still in the process of probating the estate. So it can be a complicated process. That's typically why you use an attorney. Now, if you have a small estate, you can use what's called a small estate affidavit and kind of expedite the process and eliminate a lot of the hoops. In California, that number is 166,000. So if you're worth less than that and it's all going to your spouse, you can expedite the process. But what you have is you're going to have to pay an attorney to go through the probate process for you. I said you may have to pay appraisers, et cetera. But you also have to pay the county probate fees, and it's based on a grid. And so for an example here, let's just say it's $1 million probate estate, which in Southern California, that's probably just the house. So the probate fees would be $23,000 on that, or roughly 2.3%. So the executor gets what are called letters testamentary or letters of administration. That gives them the authority to do all this stuff. And so they pay all the creditors, they file the tax returns, they distribute the assets through the term of the will. Then they have to file reports with the court saying, hey, I've done all my stuff. We close out the process, and the estate is done. So that's the probate process. It's always made to sound uglier than it actually is. People trying to promote buying estate planning packages and stuff, but it is a pain in the neck. We've helped several clients get through the process. It's costly, it's slow, and ideally we want to try and minimize probate as much as possible. Okay, so what happens if you don't have a will? Then you have the intestacy process, and each state has their order and rules, but they're all very, very similar. So typically what it is if you're married, it goes to your spouse, or in some cases, it goes to your spouse and children. If you're not married, then it goes to your children. If you don't have children, it goes to your parents. If your parents are deceased, it goes to your siblings, then other relatives. And finally, if there aren't any of those, then it goes to the state. And I actually had this situation happen last year. One of my dear friends passed away of COVID last March, and he didn't have any family. His family had all predeceased him. He didn't have any relatives at all. And I'd been bugging him for years to at least do something. And his kind of whole point of view was, what do I care? I'll be dead. Well, what happened is because Bill hadn't done any of these things, he passed away with an IRA and a bank account and other property. And essentially it all went to the state of California because there were no relatives and no one in this order of succession. So again, that's why having just a minimal will is important to have, so you avoid this situation. Okay, so that's the will. Now let's talk about a living trust, and then we'll get to the other documents in a second here. So the living trust is kind of like an alternative to the will, where the will is used only at death. You can create the living trust while alive. That's why it's called a living trust or inter vivos trust. And it essentially accomplishes the same thing. It distributes your assets, but they don't go through the probate process. And so what you have is you have a trustee who serves in that executor role. It's the trustee's job to follow the terms of the trust, and the trust spells out who's getting what and when they're getting it and how they're getting it. And so the trustee has to follow the terms of the trust. A living trust in California, or any trust in California, can essentially last 100 years. There are states where they can last much longer than that. But what's different with a living trust is it can be changed at any time. So it can be revoked at any time before death. It can be amended. Very common that this gets done. It's not a complicated process. You want to change who your trustees are, or you want to change the ages where your kids are going to get money. It's honestly as simple as writing up a Word document and have it notarized. So there's no question about, who made the changes. It's really not complicated. You don't need to go back to an attorney to get that done. Okay, so the benefits, the one that's touted a lot in these kind of living trust seminars is you avoid probate. And that's absolutely true. So you avoid the time and the cost and the hassle of probate. But I think kind of the bigger benefits are, A, there's no requirement to distribute the assets out immediately. So we're, with the will and the estate, there's usually a limited time frame to get everything out and close the estate. With a trust, you can leave the money in there forever. So, for example, maybe you have two kids. One of them is extremely responsible and trustworthy, and you'd have no problem in giving them the money right away. The other one may have bad spending habits. They may have had bankruptcies or creditor problems, or you may love your child, but you don't necessarily love who they're married to. And you're concerned that if I just give them all this money and the trust in one shot, they're going to just mingle it in the joint account, and then it's going to be lost to their divorce. So you can leave the money in trust for the benefit of those beneficiaries. The income can be used. You can be paid out for special purposes like buying a home or starting a business, paying for college, whatever. But while it's in that trust, it's still controlled by the trustee, and you don't have to worry about it being lost. Also, particularly if you have second marriages or special need beneficiaries, having a trustee and leaving the money in that trust is really important. They're super flexible. They're easy to amend or revoke. They're not public. So kind of the way to look at it is, if you're just looking at costs, going the will route is going to save you typically on cost, and it's less time to do up front, but it's going to be more costly and more time on the back end. For the living trust, you're going to pay a little bit more up front. And again, we have services that we use, so you don't have to go spend a couple grand at an attorney if you've got a fairly straightforward plan. But it certainly saves you a lot of headache, a lot of time, and a lot of cost on the back end. One thing to note, though, is a living trust is essentially your alter ego, because you can cancel it or change it at any time. It doesn't eliminate estate taxes at all. So yes, it avoids probate, but your living trust is just another asset that you own and is subject to estate taxes when you pass away, if you're subject to estate tax. So in terms of the terms of the living trust, various attorneys who draft these, we'll call them, will have different names. So you could be either the grantor, the creator, or the settler. That's the person who is creating the trust. I typically use grantor as the term that I use. So, you're a married couple, you're setting your trust up. Both you and your spouse are the grantors or creators of the trust. Then the trust document, you're going to name who the trustees are. While you're alive, again, married couple, both of you are the trustees of the trust. When one of you passes away, the other one steps into the role of the trustee. When both of you pass away, you have a successor trustee. A lot of times it's a family member, a child, or something like that, who then administers the trust. In the trust document, you're also naming who the beneficiaries are: kids, grandkids, family, friends, nieces, nephews, whatever. You can have as many beneficiaries as you want to have. You can have charity as a beneficiary. So you're naming the beneficiaries of the trust. Then you're naming the powers of the trustee, which are usually pretty broad. So the trustee could distribute income for the benefit of a beneficiary. They could distribute principal subject to what we call health, education, maintenance, and support. Maybe the trustee has the power to distribute principal to a beneficiary to buy a house or start a business or to pay for college. So you can define the powers of the trustee. The next term is, okay, what happens to the money when people pass away? So at the first death, in most cases, unless it's a second marriage or something like that, whatever's in the trust then just goes to the surviving spouse. And then, it'll go from the surviving spouse to the beneficiaries at the second death. But it could be a situation where you have a second marriage, and maybe you want some of that money to go to your kids from your first marriage. And so you would specify that in the trust document. You specify how and when income is distributed, and then you determine your terms of distribution. So very common is something like, a third to my kid at age 25, a third at 30, a third at 35. It could be different for each child. It could be that the money stays in trust forever, and it's only distributed at the discretion of the trustee. You could have sub-trusts where, one child, it stays in trust, the other child gets outright distributions. You can pretty much do anything you want with a living trust. And you create all that in the trust document, and then it's the trustee's job to follow the document and do what the trust says. Okay, so what do you put in your trust? Because a lot of people, they'll create the trust, and as Blake will talk about in the second half, is then they won't put anything in it. It's an absolute waste of time and money. So what you typically put in there, the primary ones are your home. So instead of it being titled joint tenants with right or survivorship, it goes into your living trust. The benefit being, if it's joint tenants with right or survivorship, it's fine when the first person dies away. But what happens if you both pass away? In that case, then it's probated. So you want to have that in your trust. You typically are going to title your bank accounts that are joint tenants in your trust, your individual investment accounts, your personal property, things that don't necessarily have a title, like your art collection or, cars or anything like that. Those automatically go in the trust. And then, if you have a business, you may own the business in a trust, things like that. What you don't put in there, you can't put retirement plans in there. You typically don't put life insurance in there unless we're doing it for estate planning purposes. Blake will talk about that. And you don't put annuities. Those pass by beneficiary designation. They're typically not assignable anyway. And so those may go into the trust at death, but they don't get transferred into the trust. Okay, so do you need one? The probate avoidance thing may or may not be a big deal. All depends on the other things you own and whether they're going to pass via beneficiary or whatever. But I think where they're really important is holding funds for younger kids and young adults, using it to kind of protect the funds from bankruptcies and divorces. As I said, if it's a second marriage, wanting to assure that some of the funds go to your kids from your first marriage or whatever. And if you have special needs family members, putting it in trust so it can be used for their benefit is critical as well. Super easy to amend and change. I said a little more cost up front to set up, but it's not. And if you do have to worry about estate or inheritance tax, living trust really comes into play when we have things like disclaimers and credit shelter trusts and things like that. So that's the living trust. The other documents, and these are two that everybody should have, are the financial power of attorney and the healthcare power of attorney. So the financial power of attorney is a document that allows someone you name to transact business for you on your behalf if you're incapacitated. So pay your bills and deposit checks, change investments, buy and sell property, take care of your pets, all kinds of things. So pretty much whatever you could do, you allow your financial power of attorney holder to do that if you're incapacitated. Doesn't impact assets that are in the trust because the trustee is managing those. But all the other assets you have a financial power holder. There's two versions. So if you're married, you have what's called a durable power of attorney, meaning each spouse, that power of attorney becomes effective immediately. So each spouse can do this for each other. If you're single, or when your spouse passes away, it now becomes a springing cash value, springing power of attorney, meaning that it doesn't become effective until a doctor has determined that you're incapacitated. There's definitely some protection, involved in that, so that someone can't just drain your financial assets by having a full durable power of attorney. So in most cases, if you're married, you each have a durable power of attorney to start, and the successor is springing. If you're single, it's typically springing up front. So that's your financial power of attorney. The next is your living will or healthcare power of attorney. This is where you're going to specify, do you or don't you want life support? And what are the provisions you want to have? Do you want to have things like artificial nutrition and hydration? Do you want to have pain relief? Do you want to donate organs? And if you do, is it for transplant only? Is it for all purposes? All those kind of things. And you specify your wishes. What do you want in terms of mental or physical treatments? You can be very specific, or you can leave it up to your healthcare power holder. So again, if you're married, it's typically your spouse is the primary, and then it may be kids or someone like that as the secondary. These documents, along with your will, are state specific. So one of the things you want to consider is you may get these documents, say in California, and then you move to a different state, which seems to be happening quite a bit. Now, you don't have to change your trust, but you do have to change all of these other documents because these are state specific in terms of the provisions. Okay, so I'll talk a little bit about beneficiary designations. So I mentioned, these control instead of the will or the trust. And so, the biggies are retirement plans and life insurance. So normally, if you have your 401k or IRA and you're a married couple, then you name your spouse as the beneficiary, the primary beneficiary. You may name your trust as the secondary beneficiary, or your children directly, something like that. The reason you name your spouse as the primary beneficiary is, let's say you pass away, you have two options. Your surviving spouse can roll that money into the spousal IRA and not have to take it out until he or she turns 72. Or if they're under 59 and a half, then they can leave it in your name and it's an inherited IRA, and they can take the money out without the 10% penalty. So something we have to look at. If this money is not going to be needed and they're younger, under 15 and a half, then maybe we would roll it to a spousal IRA and delay distributions. But if they are going to need the money, if we roll it to their spousal IRA and now they take money out and they're under 15 and a half, they pay the 10% penalty. So something we always have to look at. And we can do both of these things. It's not either or. So again, when we're looking at beneficiary designations, it's something we want to consider. Now, in terms of, the importance of the beneficiary designation, what you want to know is that the beneficiary designation controls. The will doesn't have any impact, your trust has any impact. So if you name someone, a former spouse or someone who's passed away as the beneficiary, that controls. And you may end up with your assets going to someone you don't want to inherit those in the future. Really important to keep your beneficiary designations up to date. Okay, so that's my portion of the presentation. I'm going to turn it over to Blake to kind of talk about some of the mistakes that we see and some strategies you can use to minimize income and estate taxes going forward.
Yeah, thank you, Jim. Appreciate it. So as you can see, life insurance, Jim talked about it, but it could be a great vehicle for estate and tax planning purposes. The reason being, the death benefit, the proceeds are paid income tax-free to the beneficiaries. So it could be a great vehicle to leave to your heirs. And as Jim mentioned in the last slide, the designation of the beneficiary, that controls everything. So you want to make sure you're checking that at least annually to ensure those designated beneficiaries align with your intent and bequest goals. So where does life insurance come in? First and foremost, to replace lost income. So to give you an example here, let's take Bob and Joan. Joan is a very high wage earner. She's the breadwinner in the family. If anything happens to Joan, it's going to have a negative effect on Bob. So why we want to have some life insurance on Joan, we want to make sure that Bob would be okay again if something that happened to her, as she's the higher wage earner of the two. Secondly, to pay off the home. So if Bob and Joan have a mortgage, and again, if something happens to Joan, Bob is still going to be responsible for those liability payments. That's where life insurance could kick in and kind of cover or eliminate all of that debt. And then offset loss of a pension or Social Security benefits. Let's just say Joan, through her employment, has a pension that she started when she retired, and her survivor benefit is 50% paid out to Bob if she were to pass away. There's going to be a gap. There's going to be a loss in income if Joan passes away. So life insurance, again, could step in and make up that gap and that loss in pension or even Social Security benefits as a way to kind of recoup the loss in fixed income. And then finally, to fund college. So if Bob and Joan have some grandkids or kids that they want to support for education expenses, life insurance could be a great means to fulfill that goal of theirs. So there's a lot of different types. We won't go into the details here, but in a nutshell, term insurance is for short-term goals or needs to cover debt, replace lost income while you're still working. And then permanent insurance is more of kind of a risk hedge for long-term people and long-term needs. Go ahead, Jim. Okay, so life insurance to pay estate taxes. Jim alluded to it earlier. There's this type of trust. It's called the irrevocable life insurance trust. It could be complicated, so I'll try to break it down in an example here. Let's just say Bob has an estate, gross estate valued at $10 million, and the estate tax exemption gets moved down to $6 million. He's single, and he has a couple kids. So if Bob passes away, his kids are going to be responsible for pay the estate tax to Uncle Sam. They're not going to get the full entire value of his estate. And that's going to put him in a crunch. So what Bob could do would be to work with an attorney to draft an irrevocable life insurance trust to where the trust buys a life insurance policy on Bob's life. And let's just call it $3 million. And then Bob can gift premiums. He can gift money to the trust so the trust can pay for the life insurance. And as long as Bob doesn't exceed $15,000 per year, then we're all good. Everything works out as planned. But the benefits to doing this is if Bob passes away, the trust can then pay the estate taxes that's owed on Bob's gross estate with the death benefit proceeds that are received tax-free. And then this policy, because it's owned irrevocably, Bob doesn't have any dominion of control or ownership, so it's excluded from his estate. So overall, a good way to kind of lower your estate and help your beneficiaries pay estate taxes. Go ahead, Jim. Okay, so let's look at some estate planning mistakes. The first and obvious one is simply not having a plan in place, not knowing or letting your kids know what happens if both of you unexpectedly pass. With this is just not having those simple 3 or 4 documents, so wanting to make sure you get at least a will, healthcare, directive, and financial power of attorney set up, not having enough life insurance. So with the current estate tax exemption, life insurance, it could or could not be a viable solution. You'd have to do an analysis, but if it does get scaled back to that 6 million exemption level, tax planning is going to be really critical. So all these legislations that have been proposed are kind of leaning towards kind of adopting more life insurance for a smooth transition to your heirs and avoiding state taxes. And then not having an elder care plan. So a lot of people don't take this into context. They don't plan for the rising health insurance costs, whether that be home health care, long-term care, or just family support, communicating to your spouse and communicating to your kids as well. Hey, if I'm unable to act on myself, who's going to step in to take care of me? Both of us are unable to do anything. Are we going to bring Billy or Susie to come in and help us? Just having an elder care plan in place so everyone's on the same page. And a kind of statistic here that is a little bit cruel, but 60% of Americans don't have an estate plan. And the real caveat is they wait too long to adopt one. So you shouldn't wait, to your 50 or 60 years old to adopt an estate plan. Adopt it as early as you can to make sure your heirs are set up for success. So some other estate planning mistakes, again, Jim talked about it here, but not funding your living trust. So a trust is only as good as the principal or corpus that's contributed into it. So you've done all this hard work, you met with the attorney, you relayed your wishes, you went back to the attorney, they executed the documents. So you've already spent all this time getting the trust in place, all these dollars that you've flushed out, but you didn't actually re-register your house under the name of the trust, put your bank accounts under the name of the trust. So you have to fund the trust after it's signed to make sure it acts as properly. And then having outdated documents. So in the past, the estate tax lifetime exemption was a lot lower than it is currently. So some attorneys try to get creative and draft these different types of A, B, and bypass trust that you might see within your documents that are kind of overcomplicated and not prevalent in today's society, today's estate tax exemption. So kind of looking at this to make sure that it aligns with where we're currently at in this environment. And then having deceased or out-of-date executors or guardians, again, making sure that everyone that's listed in your wills, in your financial power of attorneys, in your healthcare directives is alive and willing and able to step in if something happens to you. Outdated beneficiaries. So if you happen to go through a divorce, definitely review your estate documents, make sure that they align with your new goals. Maybe you don't want all of your assets to go to your ex-spouse, maybe you do, but at the very least, review them. Same with the remarriage. So if you get remarried and you want to kind of bequest some money to your current partner, if you were to pass, again, updating those beneficiaries, at least taking a look at them annually. And then again, deceased beneficiaries. So I'm making sure there's at least a contingent in place. So you want to have a primary, but also have a backup. If something happens to the primary, the contingent steps in and fills that role. And then documents kept in a safe deposit box. So if you have your trust and will and power of attorneys in the safe deposit box, that could be a mistake if the keys get lost or what have you. So to rectify that, storing it digitally, and I'll get to that shortly here. Go ahead, Jim. Okay, so what's some smart estate planning? I talked about it, but to review your documents and beneficiary designations at least annually to make sure everything checks out, to make sure it aligns with your goals, to store documents digitally. So if you work with us here at Anchor Bay, you have a personal financial website. One of the features within it's a vault. So we electronically store all your estate documents in that vault, and we tell you, if something happens to you or your spouse, let your heirs, your kids, your grandkids give us a phone call. We can relay the important details of the trust, wills, etc., to your beneficiaries to make sure, again, they're set up for success.
Yeah, just a comment there too. I think a lot of people don't realize if you have a safe deposit box and you're storing all your important documents in it, when you pass away, it's very likely that that box will be frozen. And now you have the documents that you need that you don't have access to. That's why it's critical to have digital copies and even hard copies that aren't in a safe deposit box, aren't a lockbox or safe at home.
Yeah, good point, Jim. So having an up-to-date asset and liability list, this is critical to ensure, again, your beneficiaries know where everything's at, everything that you own and everything that you owe. Something happens to Bob, does Joan know where all Bob's assets are? Does Joan know what liabilities to pay off? So making sure both partners are communicating on what the asset and liability picture looks like. And then a list of digital asset and logins. So what's Bob's, digital Facebook password or login to his bank account, all these digital assets, keeping a spreadsheet at the very least of passwords to ensure, Joan's set up for success and able to acquire all the pertinent information related to Bob's assets. Let your heirs know about your plan through a type of family meeting. So I know this could be a little bit controversial at times. You don't want your kids to know what you have. All they're going to be thinking about is the inheritance. But at the very least, telling them, hey, if something happens to us, give our financial advisor a call and they'll walk you through the process. You could go a little bit further than that and go through the details of your plan, such as assets, liabilities, your jewelry collection's going to this person, the car is going to that person. But at the very least, making sure everyone's on the same page for a smooth transition. Business succession planning. So especially, those people that have all their a lot of their assets tied up within a business. What's the plan if something happens to Joan? Is the business going to continue on? Is Billy going to inherit and operate the business, or is it going to kind of fade out and fizzle into the sunset? And then again, developing your elder care plan. This often gets overlooked, but as health insurance costs keep increasing, it becomes really important to factor in. Okay, so kind of tax planning within the lens of estate planning. Roth IRA conversions, we've talked about it a lot in our past presentations, but strategically, while you're living, moving money from your tax deferred accounts like a 401k and an IRA to a Roth for tax-free withdrawals, not only for yourself while living, but for your heirs so they can receive that money and take it out tax-free. Spousal rollover versus inherited IRA. Jim touched upon this, but Bob and Joan, Bob has an IRA, Joan's the beneficiary. They're both under the age of 59 and a half. If Joan inherits the IRA, she has a couple choices. She can assume it into her own IRA, or she can leave it as an inherited IRA and take withdrawals from that and avoid the 10% early withdrawal penalty. It would depend, again, on her age and if she needs the cash. Does she need money from the account right now, or could she wait? Stretch IRAs eliminated with the Secure Act, so it's not too common anymore. It will apply for those non-spouse beneficiaries like minors and say like a sister that's less than 10 years younger than the individual who passed away. Gifting upstream and downstream. So what does this kind of look like? Again, I'll go back to an example. Say you have Apple stock, you bought it for $10 and now it's worth $100. So your appreciation, your capital gain in Apple stock is very large. Hypothetically, what you could do if you had a parent that, for lack of a better word, was in their last couple years, you could gift it to them. And then as long as they hold Apple stock for more than 12 months, just say they hold it for a year and a half, they could bequest it to you through an inheritance. And now you get that full step up in basis. Your cost basis goes from $10 to $100 a share in Apple stock. So it's a not super common strategy, but something that definitely want to take advantage of if it's available to you. And then downstream gifting for those with larger estates, just maximizing the annual exclusion amount, $15,000 to your kids, or just coming up with other types of gifting strategies. Life insurance trust that we talked about and other estate reduction strategies. Jim mentioned this, but a lot of the techniques that you can employ to reduce your estate tax might be eliminated with these new proposals. But in addition to life insurance, there's dynasty trust, qualified personal residence trust, grant to retain annuity trust, spousal lifetime access trust, some type of complicated vehicles, but ways to reduce your gross estate. And then charitable planning, which I'll touch upon next here. Okay, kind of breaking it down, for all these charitable strategies, the first thing to consider is, are you someone that likes to give to charity? Are you charitably inclined? Do you want to leave some money to them, or do you want to gift some money to them while you're living? So just starting while you're living, gifts of appreciated property. So this is a good way for you to donate stock to a charity, and you can write off the full market value of that stock and count it as a charitable contribution to the organization. So it's a good way to get a tax write-off there. Charitable gift annuities and charitable remainder trust and charitable lead trust. These are essentially mechanisms to get a fixed stream of income, but also support a charity at the same time. A charitable remainder trust, as it implies, you're getting a fixed stream of income first, and then the charity is getting the remainder. So you'll get a set amount, and then when you pass away, that asset goes to the charity and you get a tax write-off when you set up this type of trust. Charitable lead trust, the charity gets the benefit first, and then you get some payout from your asset over a fixed period of time. Donor charitable life estate. This is essentially donating your house or other real estate to a charity. So you can live in it as long as you're alive. And then when you pass away, I want my property to go to XYZ charitable organization. So a good way to leave that to charity. Donor advised fund. This is a great kind of vehicle, again, for those that are charitably inclined. I'll give you an example here. Say you're that type of individual that gives $10,000 a year to charity every single year. So over a 10-year period, that's $100,000. Instead of doing that over a 10-year period, what you can do is give $100,000 to a donor advised fund. And then you get to write all of that, the $100,000 off in 1 year, particularly the year that you have a really high tax bracket, the year that you need it most. So you're getting that $100,000 deduction, and then you can turn around and start to give $10,000 to each of those charities in the subsequent years. And then you're not limited to one type of charity. So it allows you to diversify your gifting. Qualified charitable distributions. So a great opportunity for those over the age of 70 and a half, and especially those who are forced to take money out of their qualified plans, their IRAs, their 401ks, because you can directly give the money to charity and meet your required minimum distribution. Good way to kind of reduce your IRA and reduce future RMDs. And then give away at death. So this is kind of being strategic with your assets and what you're going to go to charity. So naming the charity as the beneficiary on your IRA, which I'll touch upon shortly. And then a testamentary charitable remainder trust. That essentially means when you pass away, a charitable remainder trust will be created. And same applies for the charitable lead trusts. All right, so let's go through an example here. So John, he's got two assets, an IRA worth $100,000 and a stock portfolio worth $100,000. John's goal is to leave half of his money to charity and half of his money to his children. John made a mistake though. He named his children as the beneficiary of his IRA instead of the charity. As a result of that, his children are going to pay income in respect of decedent tax on the IRA, 100% ordinary income taxes. So out of that $100,000 that was bequested to the children, they're only going to get $70,000 after taxes. And then Uncle Sam, gets that scot-free. And then, however, the charity makes up, they get a benefit because they get the $100,000. So let's look at the next example. So what should have John done? Instead, he should have left the stock portfolio to the children, listed the children as the beneficiaries, the transfer on death beneficiaries to a stock portfolio, to where they can get that full step up in cost basis. And then they went out by getting the $100,000. Not only do they went out, but the charity does as well. The charity gets the $100,000 because the charity is a tax exempt organization. So they don't face any income in respect of decedent taxes. So the $200,000 travels as planned and everyone's happy, and Uncle Sam falls short of his tax. All right, so how can we help at Anchor Bay? First and foremost, coordinating and developing the estate plan depends on your situation and the complexity of it. So depending on the complexity, we could either refer out to an attorney. We have a lot of vested professionals that we connect our clients with, or we can take you through our online platform Helios and walk you through step by step, understand your wishes for your estate plan, and make sure that you get your documents implemented. Estate plan designs and reviews. So kind of going back to the original thought about, when your estate plan was drafted in the early 2000s, it might be out of date. So we're going to want to review the estate plan and make sure, everything that's in it right now aligns with your goals and your kind of bequest intent. So that's making sure we're reviewing all your trust and your documents. Administration services. And then we could also prepare your state trust and individual income tax returns. Mentioned the vault, but really a good home for storing your estate documents, having that digital storage to give you the peace of mind that it's there. If something happens to you, we have it, we have possession, and we'll make sure your kids are taken care of. And then kind of overall summing it up, a deep estate and charitable planning expertise alongside family estate meetings if you'd like to do so. That's kind of how we step in. So that's kind of our presentation in a nutshell. Let's see if we have any questions. I know we went a couple minutes over.
We do. We have a question from Brandon, the best and easiest way to set up a living trust. So Brandon, what we normally do, again, it depends on the complexity of your individual situation, but if yours is fairly straightforward, we typically prefer to use the Helios service, which is essentially similar to LegalZoom, but all they do are estate documents. We've used them with a ton of clients. So they can draft all of your documents, your living trust, your will, your financial power of attorney, your healthcare power of attorney, very low cost. We can help, we walk you through the process. We help you get the documents. Depending on where you live, we can help you get them executed. If it's more complicated than that, it's a second marriage, or you have special needs beneficiaries, anything like that, then you would need to go to an attorney. again, even in that situation, we can do a lot of the legwork for you up front so that everything is kind of planned out and you can just go get the documents executed by an attorney rather than paying the attorney a couple $1,000s to have them figure out what you should be doing with your estate plan. So in most cases, we're using Helios to get the estate documents done. If you need to go to an attorney, we still would certainly work with you to get everything planned out. So you just need to go to the attorney and say, hey, execute the documents. And they don't need to bill you to do a bunch of the thinking. As I mentioned at the beginning, I specialize in estate planning for 20 some odd years of my career. So I've reviewed hundreds of trusts, if not thousands of trusts. And so we can do a lot of that front end work for you. So
Yeah, I mean, no knock on attorneys, but we prefer to cut costs to our clients, and we don't think getting a trust set up should cost $2,000 to $3,000. So we prefer to take you through the Helios service, cut costs to you, make it as cheap as possible to kind of fill in the blanks, and that's why we lead with that primarily.